In sports, particularly tennis, there is the concept of an unforced error. It's a mistake a player makes not due to the skill or effort of their opponent, but due to their own failure. An example is when two players are hitting the ball back and forth in a test of who will break concentration first and hit the ball into the net. A similar concept holds true in other facets of life, including the estate planning world. Hi, I'm attorney Andrew Bethel, and although I'd love to stand here and talk about tennis all day, this video on unforced errors we see in estate planning, particularly on the title to one's home. From DIY deeds to messy refinances, we've seen a lot of, frankly, dumb errors that could have been avoided by slowing down, taking one's time, or consulting with an attorney. So today, I just wanted to highlight some unfortunate errors we've seen so you can avoid them in your own estate planning. Everything I'll be sharing with you today are from real cases, but intentionally withholding all potentially revealing information. The first of two categories of errors I'll be discussing is where there was a company involved that should have known better. The big offender here is when refinancing one's home that is held in trust. The home is taken out of trust, but it's never put back in, and nobody knew until mom and dad passed away. This has happened 3 times, where in 2 cases, a probate was ultimately required to pass the property onto the beneficiaries of that trust. This was because a lot of time had passed in between the refinance and the death of the parents, such that the probate court judge just couldn't be sure the parents did intend for the home to be put back in trust, since they made no effort to, put it back in trust. The one case where a probate was avoided, the refinancing company made a mistake on a deed when they tried to put the property back into the trust, apparently caught this mistake after recording the initially incorrect deed, and then tried to fix the situation on at least half the property. However, the fix would not have avoided a probate entirely. The only saving grace was that the county interpreted the language of the deed very favorably for the family and reflected the entire property as being held in trust. Even then, this took a few months to finally confirm. In other cases where we have third-party companies involved who should know better, we have horror stories from online trust-building websites with little to no instructions. Houses never put in trust and a will not executed correctly meant a probate on a house with no input as to who the beneficiaries are by the decedent. Mom was doing an unequal distribution in this case too. However, because her will wasn't even valid, the house went through probate by intestate succession, meaning each of her children, many of which couldn't stand each other, now were all on title to a house together. In the second category, we have DIY deeds. These usually result in incorrect ownership or massive property tax hikes. One example is where the family matriarch put a nephew on title to help protect the property from creditors and make transition easier, or so they thought. Instead, they caused a reassessment of half the property, resulting in at least $200 more in property tax every month for the remainder of her ownership, which was something around 20 years or so. They didn't consult with an attorney prior to creating and recording the deed, so at that point, the damage was already done by the time they came in to see us, which was of course after they received notice about the increased property taxes. Other horror stories for DIY deeds we've seen are when ownership is stated incorrectly. This has happened twice, where although the circumstances were different in each case, the results were the same. The DIY deed in question only listed listed person A and person B, but failed to mention how they were holding title, joint tenants or tenants in common. Both intended joint tenants, where the interest of the first to die would automatically pass on to the other, but they both resulted in tenants in common, where the interest of the first to die stays in their estate, thus causing a probate on half the property. One was even the result of a string of DIY deeds where we actually ended up probating 75% of a house. For those that don't know, if you have a deed granting a property to person A and person B, but it doesn't explicitly say as joint tenants, then the law will presume the property is held as tenants in common, and the burden to prove otherwise is on the survivor. This is true in California and many other states across the US. A few other problems we see are mistakes on the deeds, wrong addresses for tax statements so people never receive their tax bills, quitclaim deeds where, due to an error in the legal description, the transfer was considered ineffective, meaning that the transfer hasn't taken place. In this case, a house wasn't moved into a trust as intended, but thankfully, we found it before the family would have been bootstrapped into a probate at the end of the day. Lastly, we've seen a number of instances where something as simple as the trust name being incorrectly stated in both DIY and deeds from third parties. When that occurs, we can either record a corrective deed or go forward and add an AKA for the trust name when amending the documents. Either can be a solution, although both will end up looking a bit awkward. Ultimately, the potential upside of saving a few dollars is not worth the potential downside of having to fix a problem arising from either DIY deeds or not checking the work of someone who is drafting deeds for you. It will never hurt to double check someone else's work or speak to an attorney prior to walking down to the county and recording your handwritten deed. Don't make an unforced error and hit the ball into the net. Take your time and ensure your shot is lined up and inbounds. You can never be too cautious when it comes to the title of your home. Thank you for watching. If you enjoyed the video, be sure to check out some of our other excellent videos here, but don't forget, hit the like button, subscribe, ring the bell, and tell us what you'd like for us to cover down in the comments below.